Thanks for joining everybody. This is an hour centered on protection orders. My name is Ross. I'm with the King County Law Library. I have a number of panelists on screen here with me. I think it might make sense to go one by one and introduce ourselves and say which department or who we work with. So my name is Ross. I work with the King County Law Library. The Law Library is in both the Seattle and Kent courthouses, and we exist to provide resources for folks. That includes hosting webinars like this in conjunction with the clerk's office, and providing resources in person or online or by phone. So you can always give us a call or visit our website, and we're happy to help via email or whatever else.
Hi there, I'm Angela Rognes. I'm the program manager of the King County Prosecutors Protection Order Advocacy Program, and really happy to be here today. And I will lob it to Susie.
I'm Susie Harris, and I work for the Department of Judicial Administration in the Customer Information area, which covers the protection order office, not the advocate's office, but an office within the clerk's office where we assist with processing those orders.
And I'm Ivan Sandoval. Welcome everyone. And I am a customer service division director here at the King County Superior Court Clerk's office. And I also oversee the protection order offices at our Seattle and Kent location. So again, thank you everyone for joining us today.
And so just a little look at what the hour is going to, what it has in store for us. So first, Angela is going to be talking kind of substantively about what protection orders are, their different types, what do they each accomplish, what's the basis in the law, that type of thing. And then Yvonne and Susie are going to be tackling the DJA kind of procedural, how does this get done in the courthouse? And then I'm going to wrap up after that, talking about the resources that are out there for both filing for protection orders and then also other considerations such as safety planning and things like that. At the end of the hour, we do have time set aside for Q&A. So Angela, do you want to get it kicked off?
I sure will. Okay. As mentioned, I'm Angela Rognes, Program Manager with the Protection Order Advocacy Program. I've worked with the King County Prosecutor's Office about 23 years in a variety of advocacy positions, the last 13 with the Protection Order Advocacy Program, and the last 2.5 of those as the Program Manager. Our program is really unique in the country in that we are part of the prosecutor's office, but our role, and we have 8 advocates, 4 in Kent, 4 in Seattle, and our role is to assist survivors in filing for civil protection orders. Most communities across the United States really rely on community advocates to help survivors do that. But here in King County, we rely on system advocates as well as our community advocates to provide that kind of support. When someone is considering filing a protection order, whichever kind, it's really important that they themselves, or if you're helping someone, have a really honest, frank conversation about what kind of order to file, what do they qualify for. There are 6 different civil protection orders available in Washington state, but to qualify for them, it's based on relationship and or the type of behavior that has happened that they're hoping the order can prohibit or restrain from continuing to happen. It's really important when somebody's considering an order after they figure out, do they qualify, do they want to file, and they understand the process, what the order can do. Does it match what they think it's going to do? Very often in our program, we'll talk to someone that's considering filing an order and they have expectations that don't match what these orders can do. For instance, they may say, oh, this is going to 100% stop the abuse. We hope it will, but we can't guarantee that. They may think that this can be a parenting plan or an alternative to a parenting plan, or resolve financial issues. And often these orders do not do that. Also, it's really important, is it safe to file this order? There are times where filing an order would make an individual's situation not as safe. And maybe we would recommend that they not file. For instance, if someone fled to King County from out of state, if they don't want the other person to know where they are, filing may not be a good idea, because as soon as you file and serve the other person, they've shot up a great big flag that I'm here in King County, Washington. So maybe that's not the best choice for them. Again, I mentioned there are 6 different type of civil protection orders available in Washington state. For those that are super fast at math, you'll notice I have 7 listed here. That is because I've included the restraining order. Very often when people come to the courthouse, they'll say, I need a no contact order. I need a restraining order. I need a protection order. And they use those terms interchangeably, which makes sense because TV uses them interchangeably. Other states use them differently. Here, protection orders are orders that individuals file themselves. A restraining order is one that they file in connection with a family law action. It's not a standalone order. It's something that they would file along with a motion in a parenting plan or a dissolution, something like that. All of these other orders can be filed as separate actions. The domestic violence protection order is contingent on relationship. And I'll go into this a little bit more on another slide, but a person has to currently has or have had a prior relationship to someone to be eligible for this order. The other civil protection orders do not have relationship requirements. The anti-harassment order is for someone that has been experiencing harassment that serves no lawful purpose. So if I'm really annoyed and feel harassed by Comcast, they keep contacting me with all these deals and I want them to stop. Harassment order is not the right choice because what they are doing, though maybe I feel is annoying, is lawful. They're advertising. The extreme risk protection order is unique in that it does not have a lot of the stay away restraints that all the other orders have. The extreme risk protection order is solely focused around saying that a person cannot have firearms or access to firearms, and then maybe they'll request some kind of treatment within that order. Talked about the restraining order a little bit. The stalking protection order is for someone that is experiencing harassing behavior, ongoing behavior, but it's not just annoying or harassing, it's starting to make that person feel scared or threatened or distressed. It's kind of, that level kind of goes into the creep factor. So it's not just annoyance, it's I'm starting to get really scared. So the person would apply for that order. The sexual assault protection order, the behavior is that there's unwanted sexual conduct that not consented, not wanted. Vulnerable adults is to protect someone over 18 that has a cognitive disability or somehow older that is not able to file on their own, and it's to prevent abuse, neglect, or exploitation. Domestic violence, and we'll go into this a little bit more on another slide, our definition was recently expanded, but the behavior that it's addressing is actual physical harm, threat of physical harm, stalking, harassment, and coercive control. That's the new piece that was added. Now, anyone that has a domestic violence relationship could file for these other orders. The judicial officer may change it, and we'll talk about that change as well, but they can choose which they want to order or apply for. So qualifying for a domestic violence protection order, I mentioned it really depends on the relationship, current or former, intimate partner, family member, or household member. All of those relationships that are bolded are the ones that are currently in the Protection Order Advocacy Program's service criteria. Of course, we would love to help everybody filing, but in King County, we're about 2,900 domestic violence protection orders in Superior Court alone per year. And that's been really consistent the last 4 years. That doesn't count all the other orders. So when Ivan and Susie talk about the clerk's office protection order desk being really busy, they are. because it's like that is a huge amount of people every year. A new thing that was added with the legislative update in July, when all of these orders were consolidated under one chapter, under 7.105, they added the household relationship. Parent may now file on behalf of a minor against other parents' live-in intimate partner. Okay, so previously to July, the Domestic Violence Protection Order statute was governed by RCW 2650. RCW 7.105 was the modernization and streamlining bill for all 6 civil protection orders. In the past, every single protection order had its own set of paperwork. And everyone, when someone would come in very often an emergent crisis situation, they would have to try to figure out which order applied to their situation, and that could be really hard. This new statute made a universal form, so every civil protection order except ERPO uses the same form and really embraced the no wrong door concept. So if someone comes in a crisis situation and they select anti-harassment, in the past, if they went to ex parte and the judicial officer was reviewing it and felt, no, this isn't right, it should have been a DVPO, they would say, I'm sorry, you filed the wrong action, I'm denying this. Go back to the clerk's office, get a different set of paperwork, start over. Now, the judicial officer will just change the designation, keep that paperwork, and the case can proceed. So it streamlined that and made it easier for folks that may have made just a slight error in their paperwork. This chapter also codified some processes that were introduced during the COVID pandemic, allowing petitioners to file remotely and also to appear for their hearings remotely. Of course, the courthouse is open, the clerk's office is open. People can come in person if they want, but they can also do it all remotely. So there's several pathways to the courthouse, which is really great for access. The age of petitioner was lowered to 15, so 15-year-olds can now apply on their own for several orders, and not having to have another adult do that for them. Electronic service is the presumptive service for orders, except for certain situations on domestic violence protection orders. If there's the removal of weapons, if children need to change custody, if someone needs to be removed from the home, or if the respondent is incarcerated, then personal service is required first. And I should have said this at the very beginning, but I'm so used to this language. I'm using petitioner and respondent. Petitioner or survivor, that's what we'll call them in our program. Petitioner is the one that is petitioning the court, saying this behavior has occurred and I'm petitioning the court to put this order in place and grant me the relief. The respondent is the other party. They're going to be responding to this civil lawsuit. So petitioner, respondent. And then, of course, the really big one, coercive control, was added to the domestic violence definition. Longtime advocates are super excited about this. We remember cases where people would come in and describe really scary controlling behavior, but no physical violence, no overt threat of physical violence. So those folks had no remedy. And it was really scary. Now that has been added to the definition. There was some controversy that people were concerned that people could apply and allege anything. I think our commissioners have kind of proved that fear wrong and that they're really taking their time to kind of finesse that situation. It's not just someone's being controlling, it's that this pattern of behavior is controlling the other person in such a way that it's infringing on that person's individual autonomy and ability to be a free adult. So it's much more than, someone writing, she coercive controls me or she gaslights me. The court will really require the petitioner to paint a picture of what is happening in that relationship. So does it rise to the level of actual boxing in somebody and kind of taking away their adult freedoms? Okay, so the process, and they'll go into more detail when Ivan and Susie present about how this actually works, but at a minimum, it's 2 parts. Someone comes in, fills out all the paperwork. We prefer with an advocate if that's available. They'll go to the clerk's office who will check that paperwork to make sure signatures are where they are at, they're using the correct forms. Certain pieces that are required are there. If they are, a cause number is assigned, and then they'll go to ex parte, the emergency courtroom, to decide. The court will decide if a temporary 2-week order is entered. Assuming that that is granted, then in 14 days, everybody comes back for a full hearing. The actual filing piece can be done in person or through the online submission system, which we're going to hear more about. The responding party must be served at least 5 days notice before the return hearing. Law enforcement will try their best to do that. Service issue is the most common reason a case may be delayed or reissued. So that problem solving piece, I encourage folks to reach out to our program to kind of talk about that. Even folks that are maybe outside our service criteria, we can certainly have a quick conversation about if service is an issue or finding somebody to serve, what can somebody do? And then you prepare for your hearing. Where to file: the county where you reside or fled to, or where the incident occurred. A first person can file for a temporary order at any district or superior court, whatever is easiest for them. The case will be transferred to superior court if the temporary order or the full order is going to impact the respondent's access to their children, access to shared property, or if the parties already have a superior court case pending. Jurisdiction, this is a new piece too. So you can file in King County if you live in King County. If you're filing on behalf of a minor that is primarily resides in King County, if you fled to King County or from King County. And then the new part, you can file for this order if the alleged behavior occurred in King County. So that's a new piece. Our current service criteria, again, we would love to help everybody. But right now, we are focusing on folks that have intimate partner relationships or prior intimate partner relationships, parents filing on behalf of a minor against the other parent. We do have limited ability to help on some sexual assault protection orders when someone is filing on behalf of a minor or when a minor is filing themselves. POAP advocates assist with the actual filing, but then we also assist at the return hearing. Our advocates are going to those hearings every morning, and they're Monday through Friday from 9 to noon. Typically, King County has 6 to 7 courtrooms running. They're very busy, so we'll have an advocate in each courtroom, and we try to meet with folks in breakout rooms via Zoom before or after the hearing. We also have teams that are in person, so if we find out a petitioner is in person, we'll go down to the courtroom. We are based out of the King County Courthouse and the Regional Justice Center. We have remote advocacy from about 8 to 4 p.m. every Monday through Friday. And then we have in-person services 1 to 4 at both locations. What else? And our contact information. So this is a lot of information. And I think each slide, I probably could have talked hours about each one. But please, this is just one conversation today. Feel free to reach out with troubleshooting questions or, hey, this went really fast. Can you clarify this for me? Myself and my team, we love to help out and help people figure out what order is right for them. We do have a number of people contact us that maybe we can't provide full advocacy for because they're outside our service criteria, but we do our absolute best to provide some information on how to file, how to get over those service, roadblocks, and then possible community resources. Okay, and I'm going to stop. Cannot believe I'm somewhat on time. I know
that was great, Angela.
Not either.
That was super. But you mentioned, if people have more questions or if something was so fast, what I meant to mention at the beginning of the hour is that this is being recorded. So I think the clerks maybe will have this available on their website. But I'm recording it to my computer now. So if you're wanting to rewatch this, you will be able to in the future. Sorry for not letting you know about the recording ahead of time, folks. But now we have Yvonne, who's going to speak about the clerk's office, procedure, and all that. Thanks.
Perfect. So thank you. And thank you again to everyone who's joining us today. Just a reminder, we provide several webinars on a yearly basis. And we usually provide the civil protection order webinar at least once or twice a year. And we've seen that it's very, very helpful to everyone who's joining us. So feel free to ask us questions. And then can you all see my screen? Can you see my screen? Okay, perfect. So I'm Ivan Sandoval, and again, I'm the Customer Service Division Director at the King County Superior Court Clerk's Office, also known as the Department of Judicial Administration. And just a reminder to all of you, this presentation is not intended to provide legal advice, but rather to provide procedural information. So today we will talk about some of the protection order processes from the clerk's perspective. And I'm going to go ahead and start by talking about what are some clerk responsibilities related to the civil protection orders. So basically what our role is in this whole world of civil protection orders. Number one, it's to provide and assist the customer with the process of a civil protection order. We also, at the clerk's office, initiate and process a petition and other required documentation that are related to a civil protection order case. And also we look to see if it meets the basic procedural requirements so that the clerk's office can go ahead and initiate and process the civil protection order. The clerk's office cannot assess the merits of a petition for a civil protection order. That means that we're really not looking into what people are writing into in the petition. We're basically looking at things such as, are you using the correct and updated forms? Are you signing the petition and the proposed order? Are you including the case caption that it's required for us to procedurally initiate the case? Are you submitting all the documents that you are required in order for us to initiate the case as well? Is it dated? If you are requesting for an order to surrender weapons order, are you also submitting a proposed order for that? So we're basically looking into those items, but not really looking into what people are writing in the actual documents itself. Another procedural requirement that we look into is, are you listing what type of protection order you are requesting the court to issue? Because we need to identify it. Are you really asking for a particular type? And I know that regardless of what you're requesting, the court can still issue for a whole different protection order type that it's differently from the one listed on the petition based on the situation. The clerk's office will provide the protected person / petitioner with instructions and other case information on how to appear for the temporary order hearing with the court, and a little bit more information related to this. So petitioners who are submitting petition for a protection order to the clerk's office, they have the ability to appear for the temporary order hearing with the court, either in person, by phone, or via Zoom. Everyone gets those three options, regardless if you're submitting that protection order documentation to our office in person or through our electronic system. We also provide the petitioner with copies of the publicly available documents in the case. Some of those are with a copy of the signed order and a copy of a service packet. So if a customer goes to court and then the court signs their orders, we're also giving you copies of all of that. We also provide to law enforcement agencies with the protection orders that need to be served and entered into their system. And we also provide the petitioner with the information on how to appear for their final hearing, if applicable. The next slide, it's basically about what are the required documents when submitting a petition for an emergency civil protection order. So we want to differentiate an emergency civil protection order and a non-emergency civil protection order. An emergency civil protection order, the way I look at it, is when a petitioner is asking for the court to issue, like the same day or the next judicial day, a protection order. And non-emergency, it's basically when the petitioner is asking for a protection order, but they don't need that immediate protection order. They most likely can wait 14 days out in order for them to have a hearing with the court. So for those emergency civil protection orders, the forms that we require, except for extreme risk because they're a little bit different, is that you submit a petition for a protection order form, which is form PO001. Some attachments to the petition forms are also required, depending on the situation. So for example, if minors are listed as protected persons on the petition, and the restrained person is a parent of any of those children, then attachment C of the petition needs to also be submitted. Also, another example, if a vulnerable adult if it's a vulnerable adult, then attachment B of the petition also need to be submitted to the clerk's office. Another required document, it's the law enforcement and confidential information form, which is PO003. So I know that we currently now have two. So one is the LECIF that the petitioner needs to submit and fill out, but there's also another form that it's a law enforcement and confidential information form that the respondent can fill out once they are served. And then if they want to provide the court with updated information, the respondent fills that out. And that's a different form than the PO003. Another required document in King County, it's the case information cover sheet. Basically, in this form, we are asking the petitioner to tell us if it's a case designation in Kent or in Seattle. And then I think that document also needs to be signed by the petitioner. And then obviously a proposed temporary protection order. In King County, if you are requesting a civil protection order, you are also required to submit a proposed temporary protection order. And in some cases, if you are also requesting an order to surrender weapons, you also have to submit a proposed order to surrender weapons to the clerk's office. How to submit a protection order. So the protection orders in the clerk's office, you can submit them in person. We have two protection order offices. And one, it's the one located at the courthouse in Seattle, which is 516 3rd Avenue, room E609, so on the 6th floor. And then we also have our Kent location, which is on 401 4th Avenue North, room 2C, 2nd floor in Kent. The office hours are 9 a.m. to 4:30. I think I got this wrong. It's 8:30 to 4:30. And anyone could just come in. We'll give them the forms that they need to fill out. They fill them out. We can initiate the case. And then the customer can go directly in person if they wanted to. At the moment after we initiate their case, go to ex parte, and then they can have their protection order hearing be heard by the court. Customers can also submit their petition for protection order through our KCSC portal, which is electronically and available 24/7. I included this QR code here because I thought it was probably going to be easier. If you're watching this webinar, if you want to go directly to the KCSC portal, you can just scan it in and it will take you directly to that portal. That's available 24/7. I think it's pretty simple to use. Basically, it's asking you your petitioner's first name, last name, what type of protection order you are requesting, the respondent, first name, last name, and then you just upload the required documents into there. And then it comes to the clerk's office, we'll review it, and then respond most of the time the same business day, unless it's after hours. We will process these electronically submitted protection order submissions only during regular office hours. So if a person submits something at 9 p.m. when we're closed, we're not reviewing those until the next business day. After submitting the civil protection order documents, so once they submit their petition with the clerk's office, if after submitting the petition for a civil protection order in person, the clerk will provide the customer with a card to go into court and have a temporary order hearing. So if it's an in-person, we usually give them a little, a paper, a card with their case number, and then they take that with them into court, physically into court, and then the court will know which case they're there for. After submitting the petition for a civil protection order through, there's a spelling error, through the KCSC portal, the clerk will review the documents to ensure it meets the necessary requirements to initiate and process the case. And after the submission has been accepted by the clerk office will provide the customer with the case number and information on how and when to appear for their temporary order hearing. The customer will receive this information via email and through their portal messages. The clerk will review the submissions, again, during regular business hours. Petitions for a protection order submitted to the clerk's office after 2:15 during a regular business hour. If the submission is accepted by the clerk by after 2:15 p.m., most likely the temporary protection order hearing with the court will be held on the next business day. And that's a cutoff the court has for all protection order submissions. What happens after the temporary protection order hearing? So on the same day, so on the same judicial day, the court files a temporary protection order with the clerk. So this means the customer goes to have their temporary order hearing, the court signs an order, and then if the court files that order with the clerk's office on the same judicial day, the clerk's office will provide the petitioner with copies of order or any order signed by the court, all previously submitted documents by the petitioner, so basically a service packet. And the service packet serves a great purpose because this means that, let's say the clerk's office send the information to law enforcement to serve a particular order, but if the law enforcement doesn't serve it timely, and then the respondent somehow interacts with the petitioner, and then they have not been served, what the petitioner could do with the service packet that we provide them with is basically call law enforcement, 911, and then say, hey, there's an order, and then the person is right here, they're whatever, X, Y, and Z. Here's a full service packet that you can serve on the respondent. And we also provide the petitioner an informational sheet on how to submit evidence / exhibits before the final hearing. So after the petitioner goes to ex parte, and then they have a final hearing, which is usually 14 days out, we will provide them with information on what the petitioner and how the petitioner can do to submit any other evidence or exhibits or anything related to that case that they want the court to take into consideration at the time of the final hearing. And then we also provide them with the information on how to appear for the final hearing, if applicable. And then also, if applicable, the clerk also sends the required documentation to law enforcement agencies, those listed on the court order. We send the documentation to whatever the court is telling us to send it to for data entry and for service on or before the next judicial day as required by law. The clerk's office protection order website and other resources. So here, the clerk's office protection order website, some of the things that you'll find in that website are the forms that you will need when submitting a civil protection order. You will also find resources to Washington Law Help. And this is also a great tool because Washington Law Help has one of those, I guess you'll call it an auto generator of forms. So basically customers can go there as a guest or create an account and they'll answer questions. And then you will not let them skip an answer that it's a required question. And once they're done filling out all of those questions, it will auto-generate all the forms that they need to submit them to a particular clerk's office. Also, they'll find advocacy groups information, translated information, and other resources. So our protection order website and all of their resources that we have available are now translated into other, the top 6 languages spoken in King County, aside from English. So those are, I think it's Spanish, Vietnamese, Somali, and I cannot remember all of them, but I know it's translated into 6 other languages. You'll also find recordings of any protection order webinars that we have held in the past and that we are holding, like today's webinar. That one will be posted on this website specifically. And if you need help, so if a customer wants to submit a protection order through our KCSC portal system, and you want to know, you want to find some guidance or instructions on how to do that, I put the QR code there. If you scan that QR code, it will take you directly to step-by-step on how you do that through the KCSC portal system. What other things can you do in the KCSC portal? So protection order parties can request copies of their protection order case. So basically, if a petitioner, let's say they came in for their temporary hearing and then they went to their final hearing, and then, I don't know, 2-3 months later, they still want some copies of their protection order case, they can go through the KCSC portal and identify themselves. Hey, I am the petitioner. I'm requesting copies of my protection order case. I'm requesting that these copies are delivered to me without me having to pay, because the law allows me to get access to these copies for free. They can do that, all of that, through the KCSC portal and request that. They can also submit an enforcement of Canadian protection order through the KCSC portal. We don't see these, and I don't think we have seen any since the law went into effect, I don't know, 3-4 years ago, I cannot recall, but they have the ability to do that. Messages for submissions of a protection order are translated into multiple languages as well. And so if the customer submits a protection order through the KCSC portal, all the messages that are going back to the customer, they have the ability to also view those particular messages in other 6 languages. The KCSC portal is also used for all customers to request copy of any King County Superior Court records. So that's also used for that purpose. And then basically, that is all I have from the clerk's perspective. It's basically procedural information, what are resources we have. And it's very important that if any of you have any questions or are encountering any technical issues through our KCSC portal, that you let us know. And then I just remember that I forgot to include our clerk's office contact information in this slide. So I'll go ahead and paste it somewhere in the chat so everyone can access that. And I knew I had the contact information slide. I just don't know what happened with it. So I'll just go ahead and paste that somewhere here so everyone can have that information available.
All right, that's perfect. Thanks a lot, Yvonne. Slides go missing. I understand. So let me share my screen. I think my piece will take maybe 10 minutes, and then we have 10 minutes at the end of the hour for Q&A. And I already see some great Q&A happening, and I'll be sure to go through the questions that have already been answered. So let me share my screen. So you should be able to see the safety planning screen. Was that right? Can you all see that? Okay, perfect. So just a couple things that I wanted to talk about before getting back to protection orders. But the first time that I led one of these hours on protection orders, I was communicating with some advocacy groups, and they said, well, you're going to talk about safety planning, right? And I had not intended to do that because I was new and didn't know a lot about it. Angela kind of alluded to this earlier in the hour, but the idea with safety planning is that, well, protection orders are extremely important, and they're a legally sound pathway to try to create justice and protection. But there's only so much they can do, right? The justice system, the civil justice, criminal justice system, there's only so much they can do. And sometimes they're not going to be able to keep you safe. And so the idea with the safety plan is to create a either tangible, like an actual written document, or if that's impractical or that itself is not safe, creating some kind of distinct plan in your head in advance of any kind of future situation. A protection order is often a big part of a safety plan. So of course, I'm not trying to discredit protection orders right now, but just something to keep in mind with safety plans is that they're important. So the Seattle City Attorney website that they have here, and I'm going to actually, as I go through my links, because I'm just sharing my screen right now. I don't have a presentation. I'm just going to paste these links into the chat so you can give them a read yourself. But the Seattle City Attorney website has a good kind of planning ahead during an incident, and then if you already left, considerations for developing a safety plan. I think that this is a really great, obviously local tool that you can look at. But my personal favorite from what I've seen online going through this is the National Domestic Violence Hotline. On their website, they have this link, just sent it in the chat, where it's an interactive guide where you kind of walk through, it's saying why it's important and what is it, but then it actually is a guide where you'll kind of fill this out, talking about who you are, what you plan to do, like what are your goals with the safety plan, what kind of situation are you in, and it's going to kind of walk you through the process. I think these kind of intuitive, self-guided interview style devices are super helpful, and for a safety plan, I think they make it pretty easy. So safety plan, just wanted to throw that out there. But getting back to protection orders, let me also show you on the Clerk site. They have the section on protection orders, which Yvonne had talked about a great deal. But one thing that I recently learned, I guess maybe y'all put this up in July, but on this page, there's a lot of really good information and obviously the pathways that you're actually going to follow if you're submitting electronically. But they have this protection order resources document posted on there where it's advocacy groups, shelter groups, and then also just like legal resources, talking about crisis and information lines. This document, I found this because I was trying to put something like this together myself, but then I saw that they had already put it together. And it's a really useful document, tons of organizations listed there. So I wanted to make sure, as a librarian talking about what resources are available, that everybody was aware of this document in particular. A couple other things that I wanted to go through is the POAP maintains this website, which is protectionorder.org, which is a great URL. And this has a good breakdown of the different types of civil orders. I think they might also talk about criminal orders. Yep. So you can see that they do talk briefly about no contact orders and harassment no contact orders. What I think is really super about this website, it still says under construction, but it links here. I'm not sure if you can actually see my mouse, but it says protection order process. If you click that, it opens a Word document, which has more information about safety, and then it has a kind of a bird's eye view of what the process looks like. So it says fill out the following forms, and go to the clerk's office and actually submit them. And it talks about the temporary orders and the certified copies. This is, I mean, for a 3-page document, it's super powerful, very informative. But then, so that I think that's super valuable if you are at home, maybe you have access to a printer or something like that, you're tech savvy yourself. But I wanted to make sure that you were also aware, what Yvonne had alluded to before is Washington Law Help. They have these kind of self-guided interview-based, I already have struggled to describe these adequately, but the idea is that you can start as a guest and start, it's telling me to donate right now. So you agree to terms, and it's going to start interviewing you, what's your name, what are the specifics of this case, and then provided you see it through to the end, And you can create an account and come back to it later, or you can do it as a guest. At the end, it'll spit out the forms that you need to actually file. So I think that they've done a lot, especially these new protection order forms are way more simple language. They're easier to read and fill out. I think that they've done everything they can in a lot of ways, but this takes it just a little bit even further, where you're answering one question at a time, and then you don't have to look at these. I mean, I think looking at legal forms can be kind of overwhelming myself, and so this is a way that's kind of gets around this. You're welcome to come into the library. We have tons of computers in both Seattle and Kent, where you can use our computers to fill these out, and then you can save the files to e-file. You can e-file with us, or you can e-file them later, or you can print them out at the library and walk them across the hall. That's one option. If you're in the library asking about this, chances are we're going to make sure that you're aware of the protection order advocates and the protection order office in DJA, but you are welcome to use our library computers to accomplish that. And the last thing in that way is that Washington Law Help has that great interview, interactive based option. But, sometimes people like me, other people, they want to see what's under the hood. I think there's nothing bad about the electronic interview style. But they do have a printable packet version where you can actually just download it. Excuse me, just one. So they have a printable packet where it's 55 pages. It includes the forms that you need to complete, as well as instructions on how to fill them out. So kind of walks you through what the process looks like. But then a little further on, it's going to be talking about how to actually fill out all the forms. So it says page 1 in this box, put your name. It kind of goes step by step. I think that this is a great resource, because if you want to have the printed forms in front of you, you don't have, you're not able to get into the courthouse or talk to the protection order advocates or something like that, you can read this and, have that open on your smartphone and then fill out the forms by hand. I think that this is a really great resource. Glad that the attorneys at Washington Law Help make this available. So those are the resources that I wanted to share. Looks like we have 10 minutes left, so I'm going to stop sharing my screen and we can look at the Q&A chat window and see. There's 2 open questions. I'm actually going to go back to what's been answered already, so that in case people haven't looked at that, they know that we all have the same information. So will notes or copies of slides be sent to participants after the webinar? That's true. And then also look at our websites, because we're going to be hosting this recording. Someone asked if the petitioner is pro se, they're representing themselves. How do they get the information on how to attend the return hearing later that day? And so that's going to be given to them by the clerk, is what Susie said. They're going to be provided that information before they leave the office. So that's great. It's an instant turnaround. Someone asked on the case information cover sheet, is there a form online for the DVPO? They said, I know that there is a family law guardianship CIS on file. So all the forms, Susie said, are available on the clerk's website. So it'll have all the forms listed out and linked. So that's handy. You don't have to find there's a lot of cover sheets in this world, but they lay it out thoughtfully for you. Let's see. Someone said if they have filed it online with the help of someone, will the clerk email them this information? Susie says if a party files with the clerk's portal, they will receive the information as a message via the portal account and email.
They get 2. They'll get a message in their portal, and then there's also something that's sent to their email address.
Oh, perfect.
And then you touched on the interview process, like for Washington Law Help, but the clerk's office does in fact have dedicated computers for individuals if they come in and they don't want to handwrite and they prefer to type it. We do have those available within our office for individuals to use, and it actually just saves it to a drive that the clerks can access to review and print out. The other thing that I noticed that we didn't say anything, but if you are on the clerk's office civil protection order website, there is a quick exit button. So if you're in a situation where you don't want someone knowing where you're at or what you're looking at, if you hit the county's quick exit button on that page, it takes you to the Parks Department's website, like you're looking for a park to go to. So once you click that quick exit, and it kind of follows you, so that button is always viewable wherever you go within the civil protection order site.
Perfect. Thanks for that. I didn't know about those computers, so that's really good to know. Someone asked, since protection order hearings are now heard in front of family law commissioners, how do we submit working copies when responding and replying to petitions? Will we need to file a working paper submission list? Susie says, indeed, family law commissioners are now reviewing the case files, but they do not require the working copy submission. So that's good to know. Working copies, many other types of case are important and necessary, but I guess they're getting around that here.
There is still the handout for that individuals can request a share file link if there is audio file or video file that they would like the commissioners to view. You just need to make sure that you're requesting that link ahead of time of your hearing, because if you're doing it the day of, it's not always possible to get that completed the day of.
That's right. And that information on how to request or upload any type of evidence, I guess, or whatever. Yeah, it's before the final hearing, after the temporary order hearing, but before the final hearing. The document that the clerk's office provides to the petitioner will have that information there. And that same document, it's also a copy that we are sending to law enforcement to also serve the respondent. So the respondent can also, upload after they've been served and before their final hearing to also upload any of the type of evidence there. And I know, Ross, if you're okay, I'm going to go ahead and share my screen because for some reason it says that the chat is not working, so they can't see what I'm posting there. But I wanted everyone to know to have the clerk's office protection order office information. So it's right here. Hold on. Okay. So can you all see my screen? I think you can,
yes.
Right? I just don't know when I'm sharing or not. Okay. So customers can contact the clerk's office for questions related to protection orders at our Seattle Protection Order Office, which is 206-477-0845, or in Kent, 206-477-3041. I will also say that email, it's also, we will respond even faster if we don't have anyone to answer the phones. So if you send an email to this one right here, dja.dvpo@kingcounty.gov, you'll also get an answer from our office very quickly there. And then it's going to take me only 2 minutes. I think it's important. And it's a different, I guess, public webinar too, but I also wanted everyone to see what the KCSC portal, if you have people, or if you're a law firm or an advocacy group, or you are a petitioner who wants to submit a protection order, this is what Susie was talking about. You have the quick exit button that you can click at any time. So from the main KCSC portal page, there's a button that says submit a civil protection order. You click there and it gives you all of this information. Fill out your forms first, and after you have them filled out, then you can click to proceed and submit your protection order. In order to do that, you'll have to create an account. And then after you create that account, it's basically like 4 short screens where you just submit and upload the documents that you need. And then you'll go from there. And then you basically get the messages that the clerk's office is it's sending the customers directly from the portal and also by email. But that's all I have.
That's really good. One question that I saw come through that. It turns out I was sending all my URLs for all my links. I was sending it directly to Susie and nobody else. So
Yeah.
I'm going to go into the chat and paste those now. Sorry about that, everybody.
And then one of the questions in the chat, it's also, can we request a share file access through the message feature in KCSC? No, that has to do outside of the KCSC functionality on that.
Someone had asked before, they said, are renewals still required to be filed in person only? And Yvonne had commented, yes, renewals are only in person at this point.
Yeah, perfect, thank you.
Someone asked, if you are an attorney filing for a client and using the script portal, do I need to open a separate account for the client or just use my own account?
That depends on whatever. I mean, we believe that it's important for the petitioner to get directly the messages from the clerk's office, but it's up to you. If you want to manage their account and all the messages that are going through there, including the information and when they have to appear for their temporary protection order hearing, I guess it depends on the attorney's office or the petitioner. I mean, I know that the advocacy groups will usually create an account for their clients. I mean, not create an account for their clients. I think what they do, they have their own advocacy group account. They will submit something for the petitioner and then go from there. But I think it's best, this is just my perspective, that each customer creates their own account and then manage it on their own.
Perfect. Someone asked if there is a renewal needed and it is in person, the respondent would need to be notified of that hearing in advance and be in person as well.
I know the hearing, I think most hearings are done how, Susie, maybe you know how to answer this question better than I do. If there's a renewal needed and it's in person, the respondent will need to be notified of that hearing in advance and be in person as well.
People can appear in person or telephonically or via Zoom. All that information will be on the notice of hearing that is filed for the hearing. The court does prefer people to attend via Zoom because sometimes cases are going to be heard by a Seattle commissioner and vice versa. But if someone does arrive in person, we will reach out to family law and let them know that the person is appearing in person for their return hearing, and hopefully that they can accommodate that and change where, if it was scheduled for Seattle, change it to Kent, or get this person the ability to get on a Zoom computer and attend their hearing virtually, even though they're at the courthouse.
And then one comment, as a family law attorney, I almost always send new clients directly from our office to the KC DV advocate. So I think that's your group, right? And then in any DV situation, so the divorce or parentage case will take a month to get a restraining order. Is that what OR means, I think? And then the client can proceed easily to get a DVPO on the same day. Okay.
And then I also see the question about someone using the protection order process to abuse a respondent. There are documents, we don't have them, but there are motions and such that you can present to the court for abusive litigation. It is a civil matter, but there are documents that are available, like on Washington Court's website, if that's a situation someone finds themselves in.
Well, I would also add that our ex parte commissioners are not rubber stamping every order request. I mean, they're looking at, what are the allegations that the petitioner is putting forth in their paperwork. And they're also required by statute to look up each party's criminal history and order history. So I think it would become readily apparent if someone keeps filing actions against someone else and maybe not seeing them through, or keeps filing and they keep getting denied. That's going to give that judicial officer some pause and, what's going on here? But Susie's right. There are people can file motions to restrict abusive litigation.
I think you're being addressed.
One last question remains. So someone had asked, so we need to file the working paper submission list instead of the working copy submission?
It is my understanding that for protection orders that no type of working copy or submission list is required.
That's right. You're correct, Susie. Yeah.
Then someone said, when you say presumptive service, is email confirmation of I'm assuming they made like read receipt required?
So this is a great question, and per the statute, no, but different judicial officers are interpreting that differently. Some are interpreting as long as a proof of service is filled out completely and correctly, that email service was done, and maybe a screenshot of that email, they'll consider that as completed service. Other commissioners want to see a read receipt, though not all email applications allow a read receipt. And some judicial officers are wanting to see some kind of proactive response from the other party, like I got it, or hey, how do I file my response? So I think that what happens long-term may have to be decided by some legal briefing and further actions. But so what we're advising petitioners right now is that best practice is having some kind of read receipt. We really hope respondents participate in this process by coming to the hearings. That's the best way to show that they got all of the documents and they have their chance and their day in court as well. But the read receipt is best practice. Some commissioners are not requiring it.
All right, I think it says we've answered 25 questions. We're 5 minutes over. I really want to thank everybody who did attend. I believe the clerks are going to be sending a survey after we're done with this. So keep an eye out for that. This is maybe the third time we've run this type of webinar like this, always looking to improve. So if you complete the survey, we would thank you a lot.
Thank you, everyone.
Thank you.
Yeah, thanks everybody.
Bye-bye.
Everybody have a good day.